violating the rules. And the psychologists looked at that and they said if someone is willing to risk engaging in a rule violation while they're actually involved in a resentencing, what does that say about their risk of conforming to the standards of the law if they were released outside of this structured environment? And they determined that they posed a moderate risk of violence as opposed to the low risk which had been assessed before. With Lyle Menendez, they also looked at a variety of rule violations in which he had engaged in, reaching the same conclusion, that he no longer posed a low risk of violence in the future, but posed a moderate risk. So we used this new information to renew our motion. And we said to the judge that this new information effectively meets the legal standard to allow a district attorney to withdraw a motion that had previously been filed because it shows that a change of circumstances where the prisoner is less deserving of resentencing. That is the standard. A change of circumstances where a prisoner is less deserving of resentencing. And we made that argument to the judge, and ultimately we said that the issue with the Menendez brothers is not never, that they should never qualify for resentencing. We said it was not yet. That in light of the findings of senior psychologists from the Board of Parole, in light of the prior arguments that we had made, that the Menendez brothers had never come clean for over 30 years, with the fact that their self-defense defense, where they said that their parents were going to shoot them each, the mother and the father, the night of August 20th, 1989, so they had to shoot them first. The lies where they tried to enlist one of Lyle Menendez's girlfriends to say that Jose Menendez was a violent rapist, a complete lie she would not say. The fact that they enlisted another girlfriend to go ahead and lie and say that the mother was going to and tried to poison the entire family. These are the significant lies that the Menendez brothers have never come clean with over the last 30 years. You add in the findings now by these board-certified psychologists that also talk about deceit. Deceit meaning that they no longer constitute the low level of risk, but have risen to a moderate level of risk. And that's why we asked the court to allow us to withdraw that motion at this time. It doesn't mean that we wouldn't refile the motion in the future if circumstances change to show that the Menendez brothers have truly gained full insight into their actions and accepted responsibility, but that time was not now. The court heard all our arguments and denied our motion. So the court then set the resentencing hearings for Tuesday and Wednesday of next week, at which point witnesses will be presented, and the court will either rule at that time or take it under consideration. I'm now open for questions. We anticipate that parts of that report will actually come into evidence and be considered by the court. The court will view the comprehensive risk assessment in the total context of how that plays out even for the parole board. So, for instance, that comprehensive risk assessment, though very detailed, is something that at the parole hearing would have additional information that would be brought to the parole board's light that would potentially either corroborate what's being said in that risk assessment or it could actually contradict it. The parole board will make the final call on the weight to be given to the comprehensive risk assessment, and the court will do the same as to the weight he gives to this comprehensive risk assessment.
The allegation that by Garibald's that you're using your firm lag in the campaign to, as he says, campaign against the Menendez family as a violation of juvenile legal.
So again, this shows you what happens when people want to pretend that there are facts in the record to just, to really go after someone's reputation, when they absolutely are not only wrong, but they've done no due diligence to ascertain the true facts. One of the allegations that was made by Mr. Garagos and Mr. Freeman in open court, and by the way, they made these allegations about the recusal motion as they were withdrawing the recusal motion at the same motion. So it gives you an idea of the quality of the evidence they're relying on. They said that I had hired a firm for hundreds of thousands of dollars. They identified that firm as Lag Strategy in order to put anti-Menendez messaging out there in the community. What they would have found out is that firm was hired during my campaign. It had nothing to do with the Menendezes. That firm hasn't worked for me since the campaign. The campaign was over November 5th. That firm has not put out anti-Menendez messaging. So it gives you an idea of the quality or lack thereof of the information that the Menendez brothers' attorneys and Mr. Friedman, on behalf of the victims, wants to put out, hoping that that somehow will sell in the media of public opinion. Shame on them. Shame on them to try and actually go ahead and do that. They want to go toe-to-toe with the facts and the law. Bring it on. We are happy to have a factual disagreement based on real facts, but we're happy to have legal disagreements. And that's what you've seen in sort of the interplay between ourselves and the court. But when Mr. Geragos and Mr. Friedman want to go ahead and make these spurious and salacious accusations in order to, I don't know, gain media attention, shame on them.
District Attorney, when it comes to laying out the case next week, who do you plan on hearing from, and would you like to be able to cross-examine Lyle and Menendez?
You know, the determination of who exactly will be called as a witness in the case and what, if any, witnesses or documents will be using to respond, that will be determined next week when we get closer to that hearing.
Would you like to hear from Lyle and Menendez?
Again, whether or not we hear from Lyle and Eric Menendez will most likely be a determination made by their lawyers in connection with consultation with any expert that the defense has. Again, I don't know the answer to that. They might still be on Zoom or they might appear for the hearings.
To clarify, the CRA report will not be allowed in the resentencing hearing?
So the judge has preliminarily said that he will consider the CRA, the Comprehensive Risk Assessment Report. He will also consider any arguments dealing with the weight of the report and effectively how much importance he should give to the conclusions of this Comprehensive Risk Assessment Report. Those arguments will be made by the defense in connection with its admissibility. But we ultimately believe the judge will consider the report at whatever level he deems it important.
In light of the CRA report, if Lyle and Menendez are given their freedom, do the people of Los Angeles have something to fear?
Again, the analysis is risk of danger to society. Part of the reason that we have asked not to have the resentencing go forward at this time on the people's own motion was precisely because we have this additional new information coming in from the Board of Parole senior psychologists that have assessed that risk as a moderate risk. Not a high risk, not a low risk, but a moderate risk. So again, it is a risk analysis, and that risk right now is at a moderate level.
How do you personally feel about today's ruling?
I'm sorry?
How do you personally feel about today's ruling?
Again, my personal feelings are completely irrelevant. My job, as I explained to the court, is to bring the facts, all the facts, and the relevant law to the court's attention so that the court makes the best decision possible. We did that today. So to the extent that we have accomplished our purpose, as we will today, and every day we are in court in the Menendez hearing, that is the goal.
District Attorney, your thoughts on the judge saying that the cell phone charges and the prior tax fraud, just wasn't serious enough to consider, wasn't different enough?
You know, again, the judge is making that determination. The determination, we argue to the court, is whether or not the prosecutor had a legitimate reason to take that information, couple it now with this new finding by board-certified psychologists who've conducted comprehensive risk assessments and now found a moderate risk, couple that with our other arguments of deceit that we've explained before, and then make the request to withdraw that motion at this time because we don't think resentencing is appropriate at this time. So we have made that request, the court denied it, and we respect the court's ruling.
Just to be absolutely clear, so he's going to decide during next week's hearing whether or not the CRA report is admissible?
Yes, so he will decide the final conclusion of whether or not he will accept the report and it's admissible, for what purposes, what part of the report, and what weight he will give it.
So you guys cannot use it as of now?
So again, it will be introduced in the hearing, and then we'll find out what the court's going to do with it. All right, thank you all very much. Appreciate it.
Down. Sit down, please.
Look, we're very grateful to Judge Jessic for seeing through what this was. Yet another Hail Mary. As we indicated going into this morning, I had filed a recusal motion based on the information I got. It finally has crystallized as to why and what the motivations are on Mr. Hochman. For those of you who have been around the criminal justice system for more than 5 minutes, you'll realize that for the DA himself to come in here and argue in court is not only demeaning to his deputies, who are very talented, but it shows the degree of involvement and how personal it is. It was revelatory to me that his dad and he and their law firm represented the Jose Menendez's erstwhile business partner in a tax dispute. But it basically tells you exactly why he's gone to these lengths. When Mr. Friedman, and he can talk about it, I don't know where he went. Okay, when Mr. Friedman disclosed the hundreds of thousands of dollars to start up sock puppet accounts on Twitter to defame the clients, it really crystallized exactly what this is and what this is about. It's nothing more than a distraction from the fact that this is personal for him. It shouldn't be. He's supposed to be a DA for all of LA County. He's obviously abandoned that. We'll deal with that at the appropriate time. Today, though, we're very happy that I believe this is the 4th time that he's tried and lost trying to undercut what is 35 years of remarkable work by both of the brothers, and to bring up things that were in the C files and to use reports that specifically are not supposed to be used. You know, if a defense lawyer did that, I'd be accused of every dirty name in the book. But I'm not going to dwell on that today. We look forward to coming back on Tuesday. We look forward on Tuesday and Wednesday of next week to getting yet another ruling under the standards, and so that everybody understands the reason this is important. His Honor already took jurisdiction of the resentencing. By not allowing the DA to withdraw, there is now a presumption. And the presumption is that unless Eric or Lyle is likely to commit a super strike, which nobody has suggested, nobody, that the presumption is that they should be resentenced. And so we believe that the right decision, and we have the utmost faith in Judge Jessic to do the right thing, that next Wednesday or Tuesday that they will be resentenced, and hopefully they will then go back to where they belong, which is where their family and everybody else. And that's our hope. And I'll take a couple of questions. Oh, I pulled the recusal motion, for those who want to know, for a strategic legal reason. I've explained before, we have a number of avenues or balls in the air here. We have the resentencing. We also have the habeas in front of a different judge. I did not want to, without a fully developed record, because I just got this information, and Brian will talk about it, I didn't want, without a fully developed record, to get a decision here. And somebody said in there, did you pull the recusal motion because they're so lame, or he's so lame? And I said, don't be mean. Don't say that about Mr. Hochman. But no, I wanted to get a fulsome record. We still have subpoena power, and we'll get the fulsome record. It's very troubling. I'll let Mr. Friedman talk about it, but no, that is the reason.
Are Lyle and Eric going to testify? Do you want them to testify in the hearings next week?
I don't know yet. I've got to talk to them. I mean, it's been very difficult as of late to communicate with them on a secure line. So I'll make that decision over the weekend.
So the district attorney brought up things that were found in this report about them having cell phones smuggled into prison for them while seeking this resentencing. How do you respond to that?
This is not new. The cell phone, when you say smuggled in, the cell phone violations were known. I was the one who called the previous DA and said there's a cell phone violation. By the way, last time I looked, I absolutely, and the DA's office knew it before. He would have known it himself, except he fired the deputy DA who I called on day one of doing the hard work, and then the other DA that I told he gave freeway therapy to and shipped out to Norwalk, and I guess it's too long of a drive to go to Norwalk from Beverly Hills. He was too busy coming here to do press conferences.
But does it change?
No, because I knew Kovacic would ask that question. Let me tell you one more time so you don't miss it this time. Okay, Robert? I want to explain this. I'll go slow. The standard for the judge on a presumption on DA initiated is, are they likely to commit a super strike? Last time I looked, cell phones in prison are not a super strike. Anybody else? Yes. I actually, when he brought that up, I was going to say, Mr. Hochman, are they talking about you and the potential narcissistic tendencies? That was my immediate reaction. Can you imagine if we did a psychological assessment of Mr. Hochman in this case? It would be wild to get the conclusion. With that, I'll leave you with Mr. Friedman. One question. One. Just one.
It would be a compound question.
Oh, if it's compound, I'm not answering.
Can you talk about why you are confident that this resentencing hearing is going to come up the way you want it to come up, and what is the key issue before the judge next?
The same one I was explaining to Kovacic. The key issue for next week is there a likelihood of a super strike? That is the law. Super strike is what I always call one of the 7 deadly sins. And if I have to explain that to you, Terry, then that's, I'm not talking about my confidence level. I'll give you Mr. Friedman.
Hi, Brian Friedman on behalf of the extended family members. So what was raised in court and what we learned and what was raised in the courtroom was the fact that DA Hochman has spent hundreds of thousands of dollars on a crisis PR firm, which in part has advised him concerning how to deal with the Menendez brothers situation, has advised him on what public reaction to have to that situation, what to say in press conferences, and other things. And we just recently learned of this and the involvement of, it's one thing to hire someone to be helping out in your campaign. It's quite another to be hiring a crisis PR firm to be able to deal with Eric and Lyle and that situation. So, I'm sorry?
He said he hired them during the campaign. It feels like you're making it sound like he hired them since these proceedings began.
Well, I think what you want to try to disclose is you want to disclose if you hired them during the campaign, that part of why he hired them was to be able to be advised on how to address the family members, how to deal with them, how to address the situation with Eric and Lyle. Be candid, be upfront, talk about that, get that out. I think we were all surprised that a crisis PR firm would be advising him as to how to deal with this family. It doesn't feel fair. It was raised in court. It was raised in front of the judge. It wasn't an issue today because the recusal motion was withdrawn. But if we're just looking at basic fairness, what Why would you do that? Why would you do that toward the family members? Why would you do that toward Eric and Lyle? Why would you get that advice? It's one thing to run a campaign and hire PR people for that. It's quite another one to be advised on how to best attack the family and how to best attack Lyle and Eric.
Are you going to file
We are going to file a motion under Marcy's law, and we will raise these issues, and we explain that to the court today.
Mr. Freeman, can I ask you about for next week? What do you see as the key aspect of that case for you?
I see the key aspect of next week. I see the key aspect of next week being, the Menendez brothers having a chance and having a real significant chance, and we think we have a very fair judge, and I'm sure Mark will do a great job at that hearing next week, and all the family wants is fairness. All they want is their chance. That's all.
it's hot, and I'd like to be, we don't want to keep you out
Yeah,
here.
thank you.
Hi, everyone. It's hot. I'm here from Washington State, so woo! Anna Maria Baralt is my name. Yeah. Thank you all for being here. When I was walking up to the courthouse today, I was asked, "What do you hope for today?" And my answer was, as it always is, fairness. And I think that Judge Jessic, once again, is so thoughtful in the way he examines the questions that come before the court, the way he reads the motions, the way he really lets everybody express everything that they want to express on both sides, the defense as well as the prosecution. And as a family member, that gives me great hope because I know Lyle and Eric. I know them personally. I know their growth. I've seen their journeys. And they are absolutely well suited for this process, for resentencing. And I have no doubt that if we stay fair throughout this proceedings, that we will see them out. So a huge thank you to Judge Jessic for maintaining the integrity of the court and the legal system, and to, of course, our lawyers for arguing so well.
Anna Maria, did it bother you when you heard about the CRA report and your present violation?
No. So I have not read the CRA reports. Those are confidential reports. So the lawyers have all read them at this point. I have not read them. However, I had been reassured from the beginning, from the time that they were released, by people that are actually quite neutral in this position, not necessarily on our team, and I'm not going to disclose who that was, that told me as a family member that I should take heart in knowing that there was nothing in those reports that in any way indicated dangerousness. And so for me to feel reassured as a family member, now I didn't need to be reassured because there is no doubt in my mind that there was going to be anything in those reports that indicated dangerousness, but it was very nice to hear that.
You have heard the arguments, obviously, from the people who see it differently than you. And,
Sure.
And some of them, I'm not talking about maybe the DA's argument, but some of the people from their heart feel differently. What do you have to say to those people who might just see it differently? What would you say to them?
So see it differently, how specifically?
Well, they feel that they should remain in prison.
Yeah, to those people, as I always say, that, listen, Lyle and Eric have spent 35 years behind bars. 35 years. That is a long time. Most people convicted of murder in the state of California do less than 25 before they are paroled out, right? 35 years is a very long time. I also would question anyone who would suggest that they would be dangerous if they were released today. You know, if you take Lyle, for example, he has spent 35 years in the prison system, and many of those years were at level 4 maximum security with the most dangerous people, and has not had a single violent infraction. Do you mean to tell me that he's going to be released from that environment and all of a sudden become violent? That does not make sense. That is not a rational argument. So to those people, I would say, I understand your concern. I would urge them to look at the bigger picture to see that they have already paid a huge debt to society and that they are ready for that second chance.
Mark Garagos has indicated that he has not yet spoken enough to Lyle and Eric, and it's going to be a game time decision if they actually speak to the court come next week. From the indications that you and relatives have, whether speaking with them, messaging, Facebook, social media, do you believe that Eric and Lyle do want to speak to the court?
Oh, I don't know. Those are conversations that they need to have with their lawyers. So I would never talk about strategy like that. I think that, a personal opinion, I think everybody should hear from them to some degree. I mean, they are their best spokespeople. They are really tremendous to listen to.
Having seen the details of the comprehensive risk assessment, are you less optimistic now walking out of court than you were walking in this morning?
So again, I haven't seen the details. I have seen only little snippets that were read aloud from the district attorney. No, there was nothing in that that would make me feel less confident. Yeah. Anyone else? All right. Thank you guys so much.
Good job.
See you next week.
Thank you. Thank you for answering the question. Frank!
Hey, Futterman.
You okay with what happened the other day?
What happened the other day?
No, at LAS.
Oh, yeah. They lost some good people.
Yeah, but you're okay is what I meant.
I'm okay so far. But you know how they feel about the older guys sometimes.
How do you have hope in this?
This is not a postponement. This is a moving forward, and we are very happy with the results of today.
Okay, do you think that the brothers will finally get justice? Are you hoping that, you know, everything works out and you guys?
I have every reason to believe that for them, justice means release, and I have every reason to believe that that will happen.
Unas palabritas en español, Amari, por favor, si se podría
Gracias por
tener.
el apoyo de todo el mundo, pero
¿Está contenta usted?
sí.
¿Va a estar aquí la
Sí,
próxima
soy
semana?
muy feliz, sí, claro que sí.
¿Está feliz con esta decisión del juez?
Sí.
¿Y qué opina sobre el hecho de que al fiscal, pues literalmente le rechazaron su pedido de retirar la moción de Gascón?
No sé que mi español es suficientemente
Perfectamente bien, díganlo.
para dar ese respuesta. I am hopeful for next week. I am not surprised by the district attorney's remarks. I was a little surprised that he would come make them himself. I think that there's a lot going on in Los Angeles today.
Muchas gracias.
Have you talked to the brothers? Can you tell us anything? Are they hopeful to get out? Are they ready?
They are ready for sure. They are cautiously optimistic. We are taking yet another step forward today, and that's great. No. They will be, because that is a very involved process in the Department of Corrections, so they will be appearing the way they have, via Zoom, on screen.
Buen día para la familia, ¿eh?
Careful.
Yeah, two more coming in.
Yeah, I got those two.
Hey, where we at tonight?
Okay, we're waiting for two more.
I think so. Sorry, please. Okay.
I'll just send you the door.
I'll see you later. Oh, careful, sir. Careful. Whoa.
Head back to the hotel or wait? Yeah, push back. Okay, you good? Yeah. Okay.
Out of here?
Kind of.